What's up? It's your favorite attorney. You already know what time it is. Okay? We're doing order in the court a little different now. So I'm going to call court into order and call class into session. We know that it's hard to find an attorney at 10 o'clock at night and 3 o'clock in the morning. But I can teach you how to move so that you can salvage your case and get it lined up and ready so that when your attorney comes on, they can fight and win for you. Without further ado, they wrote me and they said, when a case for felony is reset over and over again, can I write a letter to the judge? Will that help? I have a case, and there are people that are on the indictment. One of them is elderly, and since they're the defendant, they're trying to buy time so they can afford a private attorney, and they keep resetting the case. I wonder if writing a letter to the judge explaining that the elderly could die might consider as a special circumstance so that we can move the docket and get a court date. Sweetheart, law of parties, guys. There are times when you have what we call co-defendants on a case. Co-defendants on a case. And we pick co-defendants or co-triangles. That means defendant. This means plaintiff. This means defendant. So this case has multiple defendants. And they all stand sued by the same indictment. One of the defendants is elderly and is lacking money and is trying to get their own attorney. So they keep resetting the case. The only way that you can move your case along is if you can bifurcate, chop off your case, okay? And it's different terminology that is used, okay? Not all agencies or courts call it a bifurcation. Some of us call it a severance, What does it mean to sever? To sever. That means to break, to chop, to break. If there are multiple defendants, you're here, you need to get your case severed and broken off from the other co-defendants so that they can keep resetting their case and you can go on and get your trial date. The court has vested interest, has an extreme vested interest in ensuring that your case is done in the proper manner. And when you're dealing with criminal cases, people have constitutional rights because their liberty is at stake. And a judge cannot deny them any of those constitutional rights for fear of ethical sanctions. So if this person has the right to continue to reset, then I'm so sorry that's going to continue to affect you. The only way that you can stop someone else from affecting you in a case when y'all are co-defendants is if you are able to properly sever your case off from theirs. Break away your case from theirs. That's the only way you can do this, to break that case away. And you can't do that in a letter to the judge. You're going to have to do that in a called a motion to sever. And there are times where I have a co-defendant and he's got other people in the case. I don't ever want to try my case with anybody else. That's the first thing as an attorney I file is a motion to sever. And I have a hearing and I say, hey, my client's liberties are separate from theirs. My client has different justiciable interests than they do. There are reasons that I should not have my case tried along with those other attorneys. I'm against them. I don't want to try a case with them. I'm saying they did it, or they're saying I did it, or our interests are not the same. So I always run out and say, get my defendant the hell off the case with them. Because at any point in time, I may have to change my case to protect my client's right so I can fight and win. And I don't have time to be dragging along extra baggage. That might hurt my client. So I move to sever. And very rarely am I in a position where I'm waiting on somebody else's attorney, because that's the thing. It may be better for me to run along and get my case tried than to keep on waiting. So, sir, file your motion to sever. Don't write a letter to the judge, baby. And just so that you all understand, when you all start writing those letters to the judges, depending on what they say, you either implicate yourselves in further mess or further crimes, or you make people think you crazy, or you come across as difficult. Because that's what you have an attorney for. Your attorney should be filing motions. Now, there are times when an attorney is not doing what they are supposed to do. But you better make sure that that's what's going on before you start putting stuff into the record against yourself or with your case by writing letters. Because when you write a letter to a judge, it must go in the file. It alerts not only that judge, but it also alerts, who is this, y'all? The plaintiff, the state of Texas, the state of Idaho, the United States. The person trying to throw you in jail is alerted that you don't get along with your lawyer. And if they know you're not getting along with your lawyer, then they know it's go time. Press on you. Push, 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 because y'all are not getting along. Now's a good time to try to squash your case. So be very careful before you let people know that you and your attorney are not on the same page. Because everybody knows what happens to a lone lion. Lone lions get hunted. So you don't want to write a letter when you have a lawyer. Looks like you and your lawyer aren't on the same page. And if I'm a lion, I'm going to start hunting because you're alone. And I'm going to pick your ass away. I'm going to pick at you and punk you and bully the hell out of you because I know that you don't listen to your attorney and you don't get along with your attorney. So be careful in writing letters. Next case.
Biggest time I made that call. I'm locked up and facing charges. Who gon' fight these cases for me? I called Booker Law Firm. They got the job done. They were right there for me.
For more information, contact the Booker Law Firm at 713-292-2225.